Judges of the New York State Court of Appeals. The ceremony will now begin.
Good afternoon and welcome. Next month I will celebrate an anniversary that is especially bittersweet, my 13th as Chief Judge of the State of New York. The bitter part dates back to 1869, just a few years before my own arrival on the Court of Appeals, when the New York State Constitutional Convention fixed a term of 14 years for Court of Appeals judges, a compromise between those who wanted the judges to have life tenure and those who wanted only a term of years. The basis for the compromise, interestingly, was simply the statistical average of the actual length of service of judges who at that time had life appointments. Sadly for me today, back in 1869, that number was 14 years. The relentless ticking of the clock is, however, more than overcome by the privilege I have as Chief Judge, the most incredible life imaginable, far beyond my own wildest fantasies growing up in Monticello, far beyond my wildest fantasies as a young lawyer in sophisticated New York City in the 1960s. I place at the top of the list my good fortune to work alongside extraordinary, dedicated people, beginning with my Court of Appeals colleagues, Judges Smith, Saparic, Rosenblatt, Graffio, Reed, and Smith, in other words, Smith to Smith, Presiding Justices Buckley, Prudenti, Cardona, and Pigott, Chief Administrative Judge Lippman, the great judges and staff of the Unified Court System, and our partners in government and Lieutenant Governor Donahue, I'm so pleased to see you here today, and the bar. I thank and I applaud you all. While I celebrate my good fortune every day, indeed every time I enter this magnificent courtroom, this anniversary has particular significance for me. 13 years as Chief Judge, 13 good years, I would say, for the New York State courts in terms of solid performance and sound innovation have given me a unique perspective from those unforgettable first days, struggling to learn and to understand the intricacies of our vast court system, among the busiest and certainly the most complex in the entire universe. I have arrived at a point where I have a good sense of what matters most, what most needs to be accomplished. And this is my promise, my commitment, to use every precious minute of my remaining term intelligently, energetically, and constructively to see that the New York State courts continue to serve the public as effectively as is humanly possible. I start with a subject that regrettably is of great urgency for us: judicial salaries. New York State judges hold an unenviable record. We have gone without a pay increase longer than any other judges in the entire nation. Judges of our major trial courts now earn considerably less than innumerable other state employees, considerably less than federal judges with whom they traditionally enjoyed pay parity, considerably less than many first-year associates in New York City law firms. It is a profoundly unfair and demoralizing situation. While we anticipated that some financial sacrifice would be associated with a career in public service, surely no one could have expected only 2 pay increases in 18 years. Like everyone else, judges have financial obligations that come with everyday life: mortgages, rent, college tuition, and the cost of living has skyrocketed, thus in reality eroding and reducing their compensation. Basic fairness dictates that judges' compensation be adjusted to reflect changes in the economy, particularly since judicial positions are full-time and judges have prohibitions on earning outside income. 7 years without an increase in compensation is counterproductive in another sense. We are a society that needs and depends upon an effective judiciary, but this diminishes our ability to attract and retain the very best lawyers and judges, and thus ultimately is harmful to the public interest. Chief Justice Roberts and the late Chief Justice Rehnquist have made that same argument at the federal level. They are entirely correct. The time has come for meaningful action. On December 1st, we submitted to Governor Pataki and the New York State Legislature a budget request for fiscal 2006-2007 that provides for a judicial pay increase retroactive to April 1, 2005. We took this highly unusual step to draw attention to the inequitable treatment of judicial compensation. Our absolute top priority during this legislative session must be a judicial pay increase. With the unflagging support of judges throughout the state, we will remain a constant presence here in Albany throughout the coming months. We will not hesitate to make our voices heard or directly engage our partners in government as we must do. And we will work tirelessly to educate everyone in government, the public and the media, about the need for equitable compensation. Speaking of doing what is right and fair, I wish at this point to acknowledge the steadfast support of Senator John DeFrancisco and Assemblymember Helene Weinstein. They have been our champions from the outset, and they have earned our sincere gratitude. I am grateful as well to Governor Pataki, who has consistently expressed his support and submitted a judicial pay bill, and to the legislative leaders, Senator Bruno and Speaker Silver, for their support and encouragement. In fact, there's no question that our partners in the other branches fully understand the urgent need for a judicial pay increase. Their reaction and inaction on this issue has had nothing to do with whether judges deserve a pay increase. Of course they deserve a pay increase, and everything to do with issues we cannot control. And that is precisely the problem we must confront and we must resolve for once and for all. While our first order of business is to secure an immediate increase for judges, we face a deeper problem in New York State that should also be addressed. As the head of the third branch, the non-political branch, perhaps it's easiest for me to say what every single one of us knows to be true. New York's system for determining compensation for its public officials needs reform. People in public office should all be compensated fairly. Let's face facts. Too often in our state's history, we have endured long compensation droughts, forcing us to go hat in hand on bended knee to the legislature to seek large, politically unpopular catch-up increases, which sometimes have been enacted without the kind of openness the public has every right to expect. This pattern has not served anyone well. New Yorkers deserve better, as do the hardworking public officials in the executive, legislative, and judicial branches. It is high time that we take steps to change this process permanently and institute a much more responsible method for assuring compensation. Today, I announce that the judiciary is submitting a proposal to establish a permanent mechanism for the regular salary review of officials in all three branches of government. Under our proposal, judges would receive an immediate increase to reestablish parity with federal district court judges retroactive to April 1, 2005, basically the very same proposal we submitted in 2005. What's new and different, however, is that beginning in April 2007, judges, legislators, and executive branch officials would receive a cost of living adjustment, or COLA. The proposed method for establishing the COLA would be a quadrennial commission on executive, legislative, and judicial compensation, a majority of members who would be drawn from the public, and whose first business would be to determine an initial catch-up increase for legislators and senior executive branch officials. These commissions also would prescribe appropriate COLAs for the 4-year period following their deliberations, which would take effect on April 1st of each year unless abrogated or modified by the legislature. Each quadrennial commission would be dissolved after issuing its report. We make this proposal today, early in the legislative session, so that it can be fully and openly aired in the public arena. We believe that our partners in government and the public will recognize the rationality, the simplicity, the accountability, the transparency of the system we are proposing. The public would know beforehand precisely how much the salaries of high-level government officials would increase, and if economic or other conditions changed, the legislature could modify or suspend the increases. The bottom line is that we just need a better method for assuring appropriate compensation. That point was dramatically underscored for me this past year when, as the judges were visiting and imploring the legislature for long overdue increases, which the present system compels them to do, a longtime lawyer stopped me on the streets of New York City to say that he was absolutely heartbroken to see the New York State judiciary reduced to this posture. He said, "This is not what our judges should have to do." And isn't he absolutely right? This is not what our judges should have to do. We need change, and I believe that our proposal is a good, sound, and thoughtful one. And I move next to a subject of utmost concern, a second subject of utmost concern, and that is the subject of judicial selection. As I was putting the finishing touches on this report at home last Saturday, at about 6 a.m. I heard the sound of a newspaper being dropped at our front door, a soft thud that has reverberated in my mind ever since. I refer, of course, to the decision of the United States District Court for the Eastern District of New York, declaring unconstitutional and enjoining the convention system for nominating our Supreme Court justices and ordering instead that until the legislature acts, nomination be by direct primary election. As you know, for well over 2 years, our FERC Commission has been hard at work on the subject of judicial elections, by which 3/4 of our judges reach the bench. The FERC Commission issued its first comprehensive report back in December 2003, a second report in June 2004, and today its third and final supplemental report focused, interestingly, on the convention system. In their totality, these reports represent a body of work that is unprecedented in depth and in quality. The FERC Commission held statewide public hearings. It conducted citizen focus groups, sponsored a public opinion poll and a survey of judges. It met with political leaders, addressed bar and judicial groups, testified before legislative committees, and heard from numerous individuals in meetings and correspondence. The Commission's proposed changes have been the subject of 2 public comment periods. We are all indebted to the members of the FERC Commission, starting with you, John Feerick. We are all indebted to members of the FERC Commission for this comprehensive picture of our judicial election system and how to improve it. One thing now is perfectly clear, that given the extensive findings of the FERC Commission and given the extensive findings of the United States District Court, no one can any longer argue that we are dealing solely with a Brooklyn problem or a New York City problem, as I have heard some say. The issues that have been identified are pervasive, both systemically and geographically. While longer-range matters remained under consideration, I believe that the FIRIC Commission recommendations promise immediate improvement, and they should therefore go forward. Most significantly, the Court of Appeals last month approved rules establishing a statewide body, a statewide system of independent judicial qualifications commissions, or screening panels, for all candidates for elective judicial office. These commissions do not alter the current elective system, but rather they bolster it by providing credible, independent local bodies to evaluate the qualifications of judicial aspirants. The ratings issued by these panels will stand as assurance to the public that whoever ultimately appears on the ballot has been reliably found qualified for judicial service. In this regard, we are pleased to learn of the support of the Attorney General, and so pleased that the Solicitor General is here with us today, and the support of Mayor Bloomberg for independent screening panels. We are also pleased to learn of the New York State Democratic Committee's plan to establish screening panels consisting of independent, nonpartisan legal and community leaders to review candidates for Supreme Court. To my mind, that system very nicely complements our own statewide system of independent screening panels, which will cover not simply Democratic candidates for Supreme Court, but also candidates of every political stripe for every judicial post. I commend State Democratic Party Chair Assemblymember Herman Denny Farrell for recognizing the importance of strengthening the process and quality of the local party screening process. Other FIRIC commissions, now fully approved by the Court of Appeals, seek to reconcile New York's judicial conduct rules with the United States Supreme Court decision in Republican Party of Minnesota against White. They adopt monetary limits on what judicial candidates may pay for tickets to attend political conventions. They prohibit the use of campaign funds to purchase campaign-related goods and services for which fair value was not received. And they require candidates to complete an educational program on campaign ethics. Last year, happily, the legislature enacted one important FIRIC recommendation. All candidates for county and local elective office now must file their campaign finance reports electronically with the State Board of Elections. That legislation accomplishes two goals: expanding the current electronic filing beyond Supreme Court candidates and correcting the fragmentation of filing locations, which has inhibited effective enforcement of campaign finance laws. Administratively, we've already established the Judicial Campaign Ethics Center, available to all candidates who want to assure that their conduct is within the letter and spirit of judicial conduct rules. And last November, we created an online voter guide for the public with nonpartisan information about candidates for Supreme Court. That voter guide was featured on the State Board of Elections website and received well over 10,000 visitors. Finally, as I mentioned earlier, the supplemental FIRIC Commission report, which we make public today, focuses on the convention system by which political parties choose their nominees for Supreme Court. Currently, when a Supreme Court vacancy occurs, delegates to each party's judicial district convention are elected at a September primary election and convene shortly thereafter to nominate their candidates for Election Day. After careful examination, the FIRIC Commission, like the United States District Court, concluded that this system is flawed, that the current convention process fosters a public perception that delegates simply rubber stamp the choices of political party leaders and do not themselves act thoughtfully or independently. The Commission then took a very hard look at the principal alternative in this area, which is direct primaries. But without public financing, the Commission felt compelled to reject the idea of a primary system. The Commission explained that many Supreme Court justices must campaign in large multi-county districts, which means that campaign spending would skyrocket in a state that already has among the highest costs in the nation, and nothing is more destructive of public confidence in the impartiality of judges than the need to raise large amounts of money. So instead of primaries, the Commission has recommended statutory change that would result in a complete overhaul of the judicial district nominating convention system, including smaller conventions with a reduced number of delegates, longer terms for delegates to promote independence, more time and candidate information provided to delegates, reduced petitioning requirements for nomination of delegates, and a statutory right of candidates to address the delegates at their convention. Plainly, there are no quick or easy solutions here. While I am confident that the measures we take today, most notably the independent screening panels, will improve judicial elections, we could not have better evidence of the need for our lawmakers to take a comprehensive look at the entire subject of judicial selection in New York State, not just as a matter of obligation, but as a matter of opportunity. It is no exaggeration that confidence in government, and most especially confidence in the judicial branch, is at stake here. I next turn to family justice, always a major portion of our dockets, more than 700,000 cases a year, and another critical concern for us. In this vital area of the work of the New York State courts, we are this year enormously aided by the outstanding efforts of yet another exemplary group that has, over the past 20 months, given freely of its time and experience. I refer, of course, to the Matrimonial Commission, chaired by former Second Department Appellate Division Justice Sandra Miller, whose extensive report we make public today. Thank you, Justice Miller. As the report notes, substantial improvement has been made over the decades since implementation of the Malonis Commission recommendations, most especially under the leadership of statewide administrative judge for matrimonial matters, Jacqueline Silberman. Thank you, Jackie. But the highly emotional and traumatic and vexing subject of matrimonials continues to challenge us. The average time from filing to resolution has been reduced by more than half, pretty remarkable. But still, divorce takes much too long and costs much too much money, too much agony, too hard on children. The Commission concludes that we need nothing short of a cultural reform here, and I am grateful for their many recommendations that will further advance us toward that goal. As the Commission suggests, even the language we routinely use bears rethinking. Why not, for instance, parenting time instead of visitation, which seems more appropriate for prison visits, doesn't it? I cite this as an example of the comprehensiveness of the Miller Commission's examination, which begins and ends with innumerable suggestions for streamlining the process of divorce, like early screening, meaningful preliminary conferencing, classification of cases according to conflict level with strict timelines in each category, statewide integration of alternative dispute resolution methods, greater attention to issues surrounding financial and forensic experts, with many, many recommendations for administrative, regulatory, and legislative change, including, I am happy to say, support for no-fault divorce, for further study of postmarital compensation guidelines, and for efforts to mitigate some of the needless confusion and duplication caused by overlapping family court and Supreme Court jurisdiction, The report unquestionably will be front and center for us in the coming months. I am pleased to announce a new Office of Family Services headed by Justice Miller, a proactive think tank to help us develop best practices, pursue scholarship and research, and work toward the cultural change envisioned by the Commission. Thank you, Justice Miller. Thank you, Justice Ellerin, former presiding justice of the First Department. And thank you, all of your other fabulous Commission members, for putting so many really, really terrific ideas before us. You have our gratitude. Our focus on improving the lives of children in the courts, of course, isn't limited to children in divorce. We are concerned as well about the tens of thousands of children in our family courts, and we strive mightily every single day to assure up-to-date case processing methods and resources equal to those demanding dockets. Although I spent my own lawyer life as a commercial trial lawyer, since assuming the bench, and especially as Chief Judge, it's the family issues, quite frankly, that dominate my days and my nights. The recent tragic deaths in New York City put a spotlight for all of us on children's safety and the need always to assure that we do our part well. It's clear to me that as a society and as a court system, we very much need to focus more attention on the people who are served by our family court. And I'd now like to outline just a few of our many, many initiatives in this area. Last year, finally, significantly, the permanency legislation we had so strenuously supported and urged was at last adopted. To my mind, this was a sterling example of collaboration as the three branches of government labored alongside child advocates and other professionals throughout the child welfare system to bridge what had been a chasm of disagreement. Ultimately, the legislation incorporated many long-standing unified court system proposals to eliminate procedural barriers to permanency, bring the state into compliance with federal permanency standards, and help secure continuation of federal financial support for child welfare programs. Numerous elements of the law reflect the successes of our model permanency parts, and we have joined together to ensure a smooth transition to all of the requirements of the new statute. One change gives me special pleasure, and that is the rigorous efforts underway in each of our appellate divisions, and I thank the PJs, to speed up appeals in this area so that the court process itself does not contribute to the delay in securing safe and permanent homes for children. And the word collaboration brings to mind another successful joint effort, Adoption Now. In November, we marked the third anniversary of our unprecedented collaboration with the New York State Office of Family and Children's Services and the New York City Administration for Children's Services. Working together, we have significantly reduced the number of free children awaiting adoption, still far too many. And reflecting these efforts, for the second consecutive year, the state has received both an Adoption Excellence Award and an Adoption Incentive Payment from the federal government. In November, we marked another successful Adoption Week with our beautiful new family court in Kings County as the national site for the celebration. I take special joy in the fact that about half the children adopted were over the age of 9, and that Heart Galleries, providing wide public exposure to professional photographs of children in need of adoptive homes, sprang up in many locations, including Grand Central Station in New York City and the Empire State Plaza right here in Albany. I am convinced that if more wonderful New Yorkers knew about the immediately available children, they would consider adopting here rather than abroad. In 2004, Americans adopted 23,000 children from foreign nations. We have more than 4,000 free children awaiting a permanent home right here in the state of New York. Collaboration, indeed, has been a theme in yet another effort for children. For the past 15 years, I have chaired the Permanent Judicial Commission on Justice for Children, the nation's only multidisciplinary children's commission based in the judiciary. Our core mission is to improve the lives and life chances of children who are involved in court proceedings. In December, we convened the third annual Sharing Success Conference, a two-day event at the Commission, co-hosted with the New York State Office of Children and Family Services. These wonderful conferences bring together teams of judges and court staff and social services staff to focus on improving foster care operations at the local level. So many of our best practice courts that have proliferated around the state were born at the Sharing Success Conferences. We now have these courts in Erie, Monroe, Oneida, Westchester, Dutchess, Nassau, and all the New York City counties. Inspired in part by the Sharing Success model, in September, the National Center for State Courts convened a National Leadership Summit for the Protection of Children, which I was pleased to attend along with Executive Deputy OCFS Commissioner Larry Brown, ACS Commissioner John Mattingly, our wonderful administrative judges Sharon Townsend and Joseph Loria, our counsel and staff. In 2005, we began a promising new venture with child development experts from the University of Rochester School of Medicine who have agreed to operate our Children's Center in the Monroe County Courthouse. This center, like our 31 others, isn't that wonderful, 32 children's centers around the state, provides quality child care for children of litigants, connects children and families with vital services, and even conducts a literacy project that infuses the center with a reading-enriched environment and the gift of a new book for every child. Now, with the help of these medical school collaborators, Monroe County, that center, can provide the children with hearing, vision, and developmental screening and refer them to early intervention programs and health providers. The potential for partnerships between the courts and the universities is enormous, and in the year ahead, the Commission will work to enlarge those partnerships, tapping the great higher education resources we have in our state. I conclude this family justice section of my report with just a word about our court-appointed special advocates, better known as CASA. Indeed, I would consider it a great success if a caring New Yorker hearing this report would volunteer herself or himself to become a CASA. CASA volunteers, phenomenal members of the public, provide a vital resource by reporting to the courts on children and family needs and monitoring compliance with orders in child abuse and neglect cases. Nearly 800 volunteers currently serve in CASA programs operating in 34 of New York's counties. In 2004, I announced formation of a task force chaired by my beloved former Court of Appeals colleague, Howard Levine, to recommend ways we might better support CASA programs statewide. The task force has now responded with a proposal that enables CASA programs meeting specified qualifications to receive grants from the court system. I'm pleased to say that the task force's excellent plan has been approved by the administrative board for a CASA office within our alternative dispute resolution unit. My hope and my expectation is that this will enable CASA programs to flourish statewide in every one of our 62 counties, providing additional help for our courts and our children. And Judge Levine and your entire wonderful group, we are also grateful to you for your work. In the area of criminal justice as well, our efforts are fully focused on ways, old and new, to facilitate the delivery of justice. Our criminal and family court dockets together account for more than half of our caseloads. I begin with the long-awaited interim findings of the Commission on the Future of Indigent Defense Services, so ably co-chaired by former administrative judge of Bronx County, the inimitable Burton Roberts, and Professor William Hellerstein of Brooklyn Law School. While the Commission's final report awaits the completion of comprehensive data collection, it is not too soon to express our gratitude to the distinguished members of the bench and bar who, as members of this Commission, have dedicated themselves to thinking and, more importantly, to rethinking our system for providing the constitutionally guaranteed indigent defense. Having studied published materials and gathered information from scores of knowledgeable witnesses, the Commission now has convincingly, and I might say even more importantly, unanimously concluded that the existing system must be overhauled, that it is indeed not a system at all, but rather a multiplicity of modalities, all of which are sanctioned by the statutory framework within which New York State adopted in 1965 with Article 18B of the county law. Tracing the history of our patchwork scheme from its very beginnings, lacking essential standards and uniformity, the report demonstrates the utter inadequacy of our current plan. I myself have not seen the word crisis used so often or so uniformly, echoed by every single one of the sources, whether referring to the unavailability of counsel in town and village courts, or the lack of uniform standards for determining eligibility, or the county's efforts to safeguard county dollars, or the disparity with prosecutors, or the lack of attorney-client contact, or the particular implications for communities of color. One defender told the Commission that as part of his contract with the locality, he was directed to waive certain rights of his clients. Another told of being reprimanded for hiring an expert in a homicide case instead of relying on the people's expert. Virtually all institutional defenders described excessive caseloads and a lack of resources like investigators and interpreters. Some could not even afford basic office supplies. The Commission has outlined a state-funded system centered around an Indigent Defense Commission that will oversee the quality and the delivery of services. The Indigent Defense Commission would be a permanent body that appoints a chief defender for the state as well as regional defenders who together would have day-to-day responsibility to ensure the delivery of quality defense services. The Indigent Defense Commission would determine whether existing defenders provide an appropriate level of service or whether new regional defender offices should be established in particular parts of the state. All defender offices would be supervised by the Indigent Defense Commission, which will at long last develop and enforce standards applicable throughout the entire state. We eagerly await the final report, which has been promised for spring 2006, and need I remind you, Judge Roberts and Professor Hellerstein, spring 2006 is just around the corner. So we are all eagerly awaiting your final report when you will flesh out all of the recommendations and findings, and we most sincerely hope that we can move forward to redress a situation that is crying out for reform. Don't you all agree? Probation, intimately tied to the work of the judiciary, is intended to give offenders a second chance to help them reclaim their lives and become productive citizens. As we've learned from our own drug court programs, close monitoring can reduce recidivism. So can probation, with close monitoring of curfews, drug test community services, and other release conditions. Offender accountability is the key here. Accountability for past mistakes, for keeping appointments with judges, probation officers, and caseworkers, for keeping promises to do better. Under current law, the State Division of Probation and Correctional Alternatives has a general, overall supervisory role in this area. But in fact, in actuality, New York's probation departments are operated and administered locally, critically overburdened and critically underfunded. Many probation officers, many probation agencies have too few offices, too few caseworkers, little modern technology to enforce probation conditions. And because resources vary from county to county, so does consistent enforcement of probation policies. The result is a widespread perception that, at least in some parts of New York State, probation loses precious opportunities to end the cycle of crime. While state operation of probation holds the promise of consistency across New York's 62 counties, questions linger over whether local probation agencies should be in the executive branch or in the judicial branch. In New York, we've actually had both models, and which approach is better certainly deserves further study. To address the issue of strengthening probation, I announced today a task force on the future of probation in New York State, led by former Senator John R. Dunn, an outstanding Albany attorney who has also served as Assistant Attorney General for Civil Rights in the United States Department of Justice, winner, by the way, of New York State Bar Association's Gold Medal, the ultimate accolade of the New York State Bar. And John, now you're going to have to earn it. In an effort to bring together law schools, the practicing bar, and the judiciary, last spring we initiated a wonderful program called Partners in Justice. The idea was to convene an audience of judges and lawyers and clinical professors representing the state's 15 law schools around a subject of common interest. In New York State, we are blessed to have a first-rate training facility for judges and staff, the Judicial Institute, and an absolutely great dean who is here today, former Judge Robert Keating, to develop ideas such as this. The subject selected for our very first colloquium was collateral consequences of criminal charges, which include deportation, loss of voting rights, loss of licensure and employment, eviction from public housing, investigation for child abuse or neglect, and ineligibility for various governmental assistance benefits. These consequences are often not realized at the time of conviction, making it difficult for judges and practitioners to fully appreciate all of the issues that are at stake. The colloquium proceedings will shortly be published in the upcoming issue of the NYU Review of Law and Social Change. This collaborative model, indeed the colloquium itself, proved to be a huge success, leading to an innovative online search called the 4 C's, Collateral Consequences of Criminal Charges, which I am delighted to tell you will be launched, Conrad, today. This site will have high-quality content managed by experts in the major areas of New York law involving collateral consequences. The site was developed by law students from the Columbia Law School Lawyering in a Digital Age Clinic, Thomas Rosen and Alexander Schwartz, under the guidance of clinical supervisors Professor Conrad Johnson and Director of Educational Technology Brian Donnelly. They are all here today, and I'd like for all of us to express our thanks. Please stand up. I'd next like to highlight 2 initiatives, one in the criminal area, the other civil, that are this year marking a solid 10 years of extraordinary performance. First is the Center for Court Innovation, and second, the Commercial Division of the Supreme Court. The Center for Court Innovation is a public-private partnership that works to promote new thinking, new ideas about the delivery of justice today. In essence, the center is the independent research and development arm of the New York State court system, and given the breathtaking modern-day challenges we face, it's an awfully good idea. Don't you agree? In creating the center, we essentially adapted a model from the private sector. We chose to make an ongoing investment in research and development, and we chose to shield these functions from the daily pressures of managing the courts. The results have been unmistakable. The Center for Court Innovation has helped to keep the New York State court system at the very forefront of court reform for more than a decade. Over the years, the center has played a leading role in building model projects, in performing original research, in training frontline staff and providing them with the tools and the information that they need. Of the many initiatives the center has nurtured over the past decade, I begin with the Midtown Community Court, New York's original problem-solving court, in a sense our first effort to take a different look, a different perspective on the swelling misdemeanor dockets. The first community court in the country, Midtown addresses low-level crime in and around Times Square by combining punishment with help. Individuals arrested for crimes are sentenced to pay back the neighborhood through visible community service projects, and they receive on-site services like drug treatment, job training, and counseling. The goal is to make justice more responsive to neighborhood concerns and give defendants the structure and support they need to get their lives back on track and stop the revolving door of justice. Since Midtown opened its doors in 1993, we not only have opened additional community courts around the state, but we've also adopted some of its principles in a variety of other problem-solving courts, like our drug courts. The first drug court opened in Rochester in 1995, followed by several additional pilot projects, and a recommendation in the year 2000 by a Blue Ribbon Commission on Drugs in the Courts that we expand these courts statewide. Drug courts closely monitor the progress of participants in treatment programs while providing access to a wide range of services. We now have 164 drug courts operating in family court, criminal court, juvenile courts, town and village courts, with more in the planning stage. And we know from drug court graduates that these programs have a very, very significant impact on recidivism rates. That saves thousands upon thousands of lives, need I tell you, and millions of dollars for the state of New York. And using our drug courts as a model, we began a mental health court initiative for cases in which mental health treatment is an alternative to incarceration. From a single New York State pilot project in 2002, we now have 9 mental health courts operating throughout the state of New York, both, again, for the benefit of the individual and the benefit of the state. And another example is our domestic violence courts, first opened in 1996, where the emphasis is on both protecting the victim and monitoring compliance with court orders. These courts typically have a dedicated judge, specially trained staff, a resource coordinator to provide services to the parties, and on-site victim advocacy. The success of these courts inspired the development of our integrated domestic violence courts, so masterfully overseen by Administrative Judge Judy Harris Kluger, who is here with us today. And these courts are based on a one-family, one-judge concept, permitting a single judge to hear multiple cases involving the same family where the underlying issue is domestic violence. We now have 28 integrated domestic violence courts, essentially operating all throughout the state. Our intensified focus on the modern-day scourge of domestic violence in recent years has exposed inadequacies in procedures and in laws, and I'll cite just one example of an issue of concern. The legislature recently increased the possible maximum duration of orders of protection issued by family courts. But in fact, the most serious domestic violence cases are heard in our criminal courts. Currently, the maximum length of a final order of protection issued at sentencing, often just 3 years, is simply too short. This year, we will ask that sentencing judges be given authority to issue orders of protection that extend for longer periods of time in domestic violence and other criminal cases. I'm addressing this particularly to our legislators in the audience. Experience teaches us that the cycle of domestic violence often continues long after assailants leave prison, making all the more palpable the dangers of further violence and threats. We owe it to victims of domestic violence and other violent crimes to provide the very greatest possible assurance of their continuing safety, and we most strenuously urge that this proposed legislation be adopted. So as it turns out, the year 1995 was a very good one. It witnessed not only the birth of the Center for Court Innovation, but also the opening of the Commercial Division of the Supreme Court. With the Commercial Division, we celebrate both our advance into the 21st century, with courts equal to the needs of the world's financial capital, and the fact that the Commercial Division has, from its first breath, been a collaboration with the bar. Indeed, the New York State Bar Association marked the anniversary of the Commercial Division with a glorious celebration at Lincoln Center in New York City and bestowed its coveted Stanley Fold Award on the entire Commercial Division bench, past and present. That the practicing bar of the state of New York, the most skilled lawyers in the entire world, praises and honors all the spectacular judges of the Commercial Division speaks volumes, doesn't it? We're so grateful for that recognition. I have only 3 things to add on the subject of the Commercial Division. First, the court system's anniversary gift to our users is adoption of the Commercial Division rules, making practices and procedures clear and uniform throughout the state. Second, the Commercial Division continues to point the way toward more efficient case processing generally, the move toward e-filing being just one example. We will continue to shamelessly steal every good idea from the Commercial Division for the overall good of the court system. And third and finally, we this year began a series of focus groups to identify areas in which the Commercial Division might be even further improved. Facilitated by New York City Attorney Robert Haig, each group brings together a dozen or so litigators, corporate counsel, and judges, and covers a wide range of topics, and we'll soon be issuing a report on these focus groups, identifying new ideas and gaps in services that we can fill and that can successfully be applied to other types of litigation. So this is yet another example of the leadership of the Commercial Division. The focus groups have been so successful. Corporate executives and counsel have told us how greatly they appreciate the opportunity in an informal setting to express their views and offer their ideas, that we intend now to convene focus groups on a whole host of other issues, starting soon with the subject of undue litigation delays, a chilling subject. And that brings me directly to another civil justice subject that has haunted us: irregularities in the administration of estates. Last year, the Commission on Fiduciary Appointments, chaired by Manhattan attorney Sheila Birnbaum, released its second report, much of which focused on New York's system for administering intestate estates, particularly the role of counsel to the public administrator. The public administrator is appointed by the surrogate to administer the estates of citizens who leave no will and whose heirs are unwilling or unable to administer the estates. The surrogate also selects counsel to the public administrator to provide necessary legal services to these estates. Although most estates are modest, occasionally fees can run into the hundreds of thousands of dollars annually. After extensive inquiry, the Birnbaum Commission found that the process for selecting and compensating counsel to the public administrator needs strengthening, and it found frequent instances of close ties between surrogates and persons appointed as public administrator as counsel or counsel. Based on the Birnbaum Commission's recommendations, the Administrative Board of the Courts has just approved a series of measures that will address these problems. First, the disqualification provisions of Part 36 fiduciary rules will now also apply to the public administrator and to counsel. By disqualifying persons who have political, personal, or business connections to the surrogate, we assure the public that these fiduciaries are being appointed on the basis of merit. Second, awards of counsel fees over a certain amount will have to be publicly reported, so that if a surrogate departs from the schedule a written statement of reasons and the council's affidavit of legal services will have to be made available on the internet for public review. These requirements will bring sunlight to this area and enable interested parties to monitor compensation. A third rule will require the surrogates to provide regular reports on the performance of the public administrator and council. And finally, we'll be sending the legislature a proposal to mandate that fee schedules promulgated under Surrogates Court Procedure Act, Section 1128, be binding on the surrogates, while preserving the surrogate's discretion to award higher legal fees in limited circumstances upon a showing of good cause. Needless to say, effective oversight is critical to a system charged with administering thousands of estates that lack interested parties. I conclude this section of my report by once again heartily thanking the extraordinary members of the Birnbaum Commission for enabling us to change a culture. It continues to amaze me that, busy as all of those people were, they nonetheless asked to remain on after submission of their report to address the council issue, and once again they did it efficiently and superbly, which leads me to pause to congratulate and thank all the many wonderful people who have given so generously of their time to chair and serve on our many commissions, committees, and task forces, starting with the first matrimonial committee and the jury project, and up to today's report of June Castellano's commission to examine solo and small firm practice. Hundreds of judges, lawyers, and members of the public have contributed their time and very best efforts. The New York State Bar, in particular, has been our constant partner in every one of these efforts. From the first to the last of my term, two subjects are of transcendent concern: pro bono legal services for the poor and our jury system. And just a word about each. This year, we're going to try an entirely new approach to reducing the gap in the availability of legal services for the poor. This year, we are going local. Our statewide initiative is a grassroots effort that partners the bench, the bar, legal educators, legal services providers, and advocates in each judicial district. And by the spring, we will have every one of our local committees fully formed and have their assessments completed. Now, the printed copy of this message, you're hearing, and aren't you grateful that you are, only an abridged version of my message. The printed version of my message details the work, in particular, of three local action committees, the 5th, the 8th, and the 9th, which serve as leadership models, and we have great, great hope for the success of this new approach. Given the severity of need in family law and matrimonial matters, each of the local committees additionally will be asked to include a pro bono matrimonial panel in its plans, and Deputy Chief Judges Juanita Bing Newton and Jacqueline Silberman are jointly developing a statewide training model on how to handle uncontested divorces using a newly designed and user-friendly matrimonial packet. We have more than 50,000 uncontested matrimonials a year in our state court system. This model that's being developed will do a lot of good for a lot of people. We're so pleased that you've focused on this. And that brings me to the second enduring concern, juries. Since 1993, always we have had a jury initiative in place, and Norman, I know how delighted you are, Norman Goodman, County Clerk in New York, most afflicted by these wonderful ideas. Always we've had a jury initiative in place, and Norman, I assure you, always we will. There has been tremendous improvement in the jury area. Don't you all think so? I think so. We have so much more to do. Just now, we are hard at work on dozens of initiatives to make our jury system more juror-friendly, automatic postponement on the web, an even more simplified summons, reduced grand jury terms, a new grand juror's handbook. That's just a small sample. And we have an ongoing model jury pilot project in Queens County, which has been briskly moving ahead on reform on all fronts. At the same time, and this is such an exciting project, a group of 51 judges stepped forward to pilot some of today's innovative trial practice. practices, and they issued a report in April recommending that trial judges throughout the state permit jurors to take notes, allow jurors to submit written questions, and provide jurors with jury instructions in writing. We would like more lawyers and more judges to try these and other practices. They do improve juror compensation and juror satisfaction, and we've produced a wonderful practical guide to assist everyone who wishes to go forward with these plans in doing so. I've labeled this final section of my report potential regrets, but the fact is I intend to have absolutely no regrets. So I am turning immediately to two subjects that have tormented me all my years as Chief Judge, with the intention that steps taken now could make a real difference. The first subject is public outreach, and the second subject is, can anyone guess, restructuring. A gnawing concern has been what I perceive as a lack of public knowledge and understanding of the courts. Respect for the law depends on public confidence in the integrity of the justice system, yet we know that trust in public and private institutions in the United States has been declining ever since the 60s. New Yorkers' own first-hand encounters with the courts tend to be brief, and they tend to be sporadic, like a traffic court or small claims appearance or a jury summons, let's face it, not among life's most cherished moments. Depictions of the courts and lawyers in pop culture and the media often serve only to reinforce negative views. We deserve better. We deserve much better, and I believe that the court system's leadership here can and will make a genuine difference. Using the model for the Center for Court Innovation, we will be developing a Center for Courts and the Community, a nonprofit public-private partnership that will focus like a laser beam both on fortifying educational partnerships for school children and adults and on establishing programs to inform and facilitate the work of the media. We are well aware of tremendous ongoing efforts in these areas in New York State and all across America, and of our terrific State Bar President Vincent Bizard's special interest and work in improving public understanding of the legal system. Our intention is to learn about and build upon every single one of these great efforts, and that brings me to restructuring. Restructuring. Since 1993, I have urged simplifying the archaic structure of New York's courts, by far the most complicated in the universe. Supreme Court and Family Court, Surrogates Court and the Court of Claims, Superior Criminal Courts and Local Criminal Courts. Time and again, whether the issue is matrimonials or indigent defense or simple efficiency, we have seen that jurisdictional barriers among New York's trial courts fragment related cases, risk inconsistent judgments, discourage effective outcomes, encourage costly litigations, and confuse litigants and lawyers. We've had some notable operational successes, like the Integrated Domestic Violence Courts and the Bronx Criminal Division. Despite these heroic efforts to work around the problems, however, there is no escaping the conclusion that our court structure needs repair. I am discouraged, but I am not deterred by the fact that my perennial call seems to be unheeded. Indeed, 2006 marks a full century since Dean Roscoe Pound's historic speech to the American Bar Association, calling for states to unify their trial courts for the sake of efficiency and justice. Over the last century, other states have heeded that call, and indeed in 1962, New York took the modest step of merging and unifying some of its courts in New York City. But 11 trial courts is still a far cry from what Dean Pound envisioned when he urged unification, and a far cry from what Chief Judge Charles Breitel urged in 1974 when he joined that call. Ensuring accountability, better protecting crime victims, reducing recidivism, reducing costs, making our courts more efficient, more accessible, more understandable. I have come to see more than ever before that without change in our court structure, these benefits will continue to elude the state of New York, given the frustrations we've experienced in getting court reform off the ground, I'm convinced it's time for a new approach. So I wondered, how did they do it back in 1962? And I learned that that effort was actually inspired by the work of a commission set up in the mid-1950s, chaired by New York attorney Harrison Tweed, that studied the need for structural reform and modernization of New York's procedural codes. Recognizing the success of the Tweed Commission and the successes we have had in the last decade, I will be forming a special commission on the future of the New York State courts to pick up where the Tweed Commission left off. The commission will be asked to look at systems across the nation for ideas and to propose a court structure that is free of barriers that force the unnecessary fragmentation of courts and cases, that is user-friendly, that has the benefits of both specialization and simplicity, that is accessible to all New Yorkers, and to suggest procedures that complicate such a streamlined system. Now, having reached the end of my message, I should disclose my vantage point in preparing it. In giving you this overview, actually, I was flying low over the court system, about 1,000 feet off the ground. There are so many operational initiatives in every corner of our court system. Were I at ground level, this report would be many, many times longer. But whether at ground level or 1,000 feet above, I would say that the state of the New York State judiciary is good. With the improvements noted in this report, it would be even better. The goals of great collaborations, solid performance, and sound innovation have been the guidepost of the past 13 years, and they will continue to motivate us in the year ahead. Thank you all for your interest, for your assistance, and for your support.